So there have been some interesting takes. So obviously, let's get over to Pokemon versus Palworld. So we have a lawsuit, Pokemon versus Palworld. I covered the basics. This the original statement from Pokemon, which was we are suing to protect our patents. It's a patent infringement lawsuit. The one thing I want to start out with real quick, clearly here, and this is something I'm going to repeat, is this is patent law. Patent law is not copyright. Both copyright and patent are types of what we call intellectual property law, but they're different. They're different. They're as different as, for example, different crimes. So, for example, burglary and murder are both crimes. They're both crimes that you fall into the parameter of criminal law. So you'd say, oh yeah, criminal law, burglary, murder, right? But they're different. The elements of those are different. What you need to satisfy or prove those in court is different. You can't come to a murder case with proof of a burglary and try to prove that the burglary happened. Same thing with patents and copyright. The elements are different. The requirements are different. I'm going to explain a couple of these things to you right now. One of the biggest differences between copyright, which generally is used to protect broader concepts, ideas, things that might pertain to a story, for example, or a movie, or an artistic work, or other forms of artistic expression, right? Versus a patent, which is generally used for inventions and processes. So things involving hardware, software, things involving mechanical systems, right? Those sort of things that are on that side of the register. Now, beyond that, copyright exists whether or not you register it with the state. Whether or not you register your copyright, you still have a copyright the second you create something. So if someone goes out and tries to steal your book, and you wrote a book and they steal it verbatim, they plagiarize the entire thing, and you never registered it, it doesn't matter. You can still go after that person, right? You have a copyright interest. You have a protection of what you have made because you made it. And it's the second that you made it. Patents are not like that. Patents need to be registered. There is a race to registration when it comes to patents. If somebody was to find out about an invention and then go race out and patent it, they can screw you. And that's why trade secrets are important. That's why protecting certain formulas or other things is important, because if somebody gets out ahead of you or steals your research, some sort of industrial corporate sabotage or spying or espionage, that's a big problem. That's a real big problem. And that's a hard stop. That can be a hard stop. If someone gets a patent on something, it can stop you from advancing down a line of technology. And there are people out there called patent trolls, and whether companies and groups that actually try to block lines of research by going out there and paying and holding up the troll toll and making you pay to use that specific line of research or that specific line of innovation. It's a big thing. Also, we'll talk about this. Patents are relatively international. Now, at first, I did mention, and I always mention, hey, just let's be aware this is being filed in Tokyo, not in America, right? So a lot of people were applying like all of American law. Now, that said, there are some procedural differences in Japan. There are some differences with exactly how they register their local trademarks, patents, copyrights, etc. But generally, most of the world follows the PCT, which is the Patent Cooperation Treaty. In fact, you can see here the Patent Cooperation Treaty has 157 cooperating states. Pretty much the only places that are out of this are Pakistan, Afghanistan, Yemen, Somalia. You've got Argentina, Uruguay, and that's about it. Even North Korea, guys, even fucking North Korea. Oh yeah, Burma's in there too. Even North Korea is down with the Patent Cooperation Treaty. Like pretty nuts. Pretty nuts. So even China, yes, I know someone actually, you know what's funny? So people are wondering about China. So China, the funny thing about China is that they actually moved to the top slot for patent registrations under the PCT. So China currently registers more patents than the United States. United States used to be number one. Also up there in the rankings is Japan, of course. Watashi wa, lots of patents, right? And then you've got South Korea. South Korea, they got kimchi and they got patents as well. So South Korea, Japan, US, China, all up there being Chad-like in their amount of patents. And by the way, if you think about most of the patents being filed in the United States, they're probably a lot of them are also filed. A significant number are probably filed by people of Asian descent in America. But that said, yeah, there are things that are upheld in China. And actually, I forgot to pull up this article. Let me pull it up real quick. Pokemon just won a lawsuit in China. So for all of those that and this was to me shocking, right? So there was a copyright suit, not patent, copyright suit. Hold on, let me pull this up in Brave because I love bounding into comics. I love those guys, but they put a half page worth of ads on their site, which is quite annoying. All right, here we go. So thank you, Brave browser, for blocking most of this. All right, here we go. Okay. No, I'm not installing your plugin. Okay. Pokemon just won a $15 million copyright lawsuit in the Shenzhen People's Court for $15 million in damages. Now, this is against the game, right? Against the turn-based Pocket Monster reissue, right? So they won that case. Now, Pocket Monster reissue, this knockoff that was made about $42 million annually. So originally, Pokemon Company sued them for $72 million. However, they only got 15. So they didn't get all their profit. So they got a big win, but they didn't get all their profit. But even to win in China is huge, guys, because this has never been a thing. So the fact that Nintendo can go out here and win in China is really impressive. And to be honest, from what I know of their litigation history, they usually win. Not always, but usually. There have been occasional times where they have taken an L. But the fact they won in China is, I was surprised. I was like, I mean, that just doesn't happen. You have major American companies that can be just blown out of court in China. So very interesting. But Nintendo is very litigious. They are very litigious. So here we have the Palworld statement regarding the lawsuit. This is from Palworld DN on their official account on X. Okay. Yesterday, a lawsuit was filed against our company. And we have received notice of the lawsuit and will begin the appropriate legal proceedings and investigations into the claims of patent infringement. At this moment, we are unaware of the specific patents we've been accused of infringing upon, and we have not been notified of such details. So this is true. Now, we are all speculating on which one it's going to be. And there's a particular mechanic that we're all speculating on, which was the ball catching mechanic, which is one they indeed have patented. Now, just because that's the one that we're all focusing on the internet doesn't mean that's the only one. In fact, they said it infringed on multiple patents. So I assume that there's going to be more than one that Palworld is allegedly infringing upon, so that they're going to kind of shotgun approach that, right? Okay. Pocket Pair is a small indie game company based in Tokyo. Our goal as a company has always been to create fun games. We will continue to pursue this goal because we know that our games bring joy to millions of gamers around the world. Palworld was a surprise success this year, both for gamers and for us. We were blown away by the amazing response to the game and have been working hard to make it better for our fans. We will continue improving Palworld and to strive to create a game that our fans can be proud of. It is truly unfortunate that we will be forced to allocate significant time to matters unrelated to game development due to this lawsuit. However, we will do our utmost for our fans and ensure that indie game developers are not hindered or discouraged from pursuing their creative ideas. We apologize to our fans and supporters for any worry or discomfort the news has caused. As always, thank you for your continued support of Palworld and Pocket Bear. By the way, guys, and I'm going to like this because I haven't liked it yet, but I like it. And shout out to my boy Knight posting down here the Dragon Quest versus Pokemon. Of course, once again, not necessarily relevant to this suit, but a cute comparison. It's really interesting because Palworld has a shit ton of support in the West and from the West. So the Westerners are behind Palworld. But the funny thing is that within Japan, the general sentiment is on the side of Nintendo, right? And there's two parts to that. One of it is national sentiment, just because, you know, when you think of Japan, you think of Nintendo, right? So it's like, you know, if you're Japanese, it's about as tied in as, you know, Honda or Yamaha or any other big Japanese corporation. They do love their big Japanese corporations. They're part of Japanese society. They very much love them and have their identity tied to them, much like Samsung in Korea, right? Very, very similar. So that's one of the reasons. The other reason is just supporting the general support for like creators bringing lawsuits, like, and just backing up and presuming the person that sues is in the right, because generally they are, right? So there's part of it there. But it's very interesting, that dynamic. That, don't read into that whether one is right or one is wrong. It's a very interesting dynamic from a support basis. Let's get into this. So where is Grum's wrong? How am I going to yell at old Mark? Let's yell at Mark. So Mark over here, Mark Kern on Grums over here on Twitter said, Palworld exploded on the scene in February. Patent about Pokeballs filed in May. Patent granted in August. Pokemon sues Palworld the following month. Folks, this is Nintendo using lawfare to try and kill an indie studio that embarrassed them by creating a better Pokemon-style game than they did, and I don't support it. After all these years, they only filed a patent this year. So focusing once again on the fact that the patent was filed in 2024, right? And over here you see it as well, right? Filed later. Okay, so here's why this is not as big of an issue as you think. And this is actually on an article which I haven't seen quoted anywhere, but it's a great article, and it's citing a Japanese lawyer, Kiyoshi Kurihara. So he's a Japanese guy. He's a patent attorney, and he is breaking into this analysis. So let's read this analysis by Kiyoshi, and why, in particular, it is such a damning patent to have filed. So he starts by saying, as you know, this is his opinion, right? Once again, as a Japanese lawyer, there have been opinions about Palworld's monsters being similar to Pokemon in form. However, this is not enough to ascertain copyright infringement. They come close, but they're narrowly avoiding it. So in his opinion, as a Japanese lawyer, he is saying that, in his opinion, as a Japanese lawyer, under the Japanese system, at least whatever rules they're playing by, that's not going to be enough to be copyright infringement. Okay. So that's why they went through patents. So what are the patents? So aside from the monster designs, Palworld's game system does not seem very similar to Pokemon. And it seems to be an open world game similar to Ark, right? Similar to Ark. So the people who mention Ark, the chads in the chat who mention Ark, there you go. There you go. It's more of an Ark than it is a Pokemon. If there is a common point, it is the mechanic whereby you throw a ball-like object at monsters to capture them. If there is any patent infringement to speak of, I think it would be this. So in his opinion, that mechanic is the one right there. Right? So since the lawsuit against Pocket Pair was filed jointly by Nintendo and the Pokemon Company, Kurihara assumes the patents in question have to be jointly registered by both companies. This narrows down the possibility to 28 patents. Further, there are 4 divisional patents that Nintendo and the Pokemon Company registered after Palworld's launch. We're going to get into what a divisional patent is. Right? For extra context, a divisional patent is a type of patent application that contains isolated content from a parent patent that has already been registered previously. It is usually used to split up a patent that describes multiple technologies. Let's take a pause here and let's go over to a graphic, because I love graphics and I found this nice graphic provided by the Europeans, showing you that Europeans can occasionally do things correctly. This is by the European Innovation Council. But as you can see here, this explains what a divisional patent is. So a divisional patent is a strategy, right, whereby you take a parent patent, so an original patent, and you split it. Now, why would you do that? Well, there's several reasons. The first is that technically every patent is supposed to be for one invention, okay? So if there is something that is potentially for multiple inventions, you want to break that out into further subdivisions. Now, what they did was they took their existing patent, which existed before Palworld was ever developed. So they took their original patent and they split it into a bunch of divisional patents. They split it. Now, here's the other thing about a divisional patent. When you do this, the new patents, yes, they're issued as of the date, but they're enforceable on the date of the parent patent. So when you file and receive a divisional patent, let's say this one was filed in 2020 and this one comes out in 2024, you can enforce this as if it existed in 2020. So if you filed a patent in 1990 and you divide it in 2024, you can go back and enforce it as of that date, as of that prior date. And that's why the date issue is irrelevant. And all the people on the internet talking about the date issue aren't understanding this concept. And frankly, I didn't even get this concept, right? And it's used, by the way, as a litigation strategy. Here's why. Because imagine you have a lawsuit and you have your one parent patent and it has multiple concepts in it. Well, first of all, they can get that patent invalidated because it's not supposed to have multiple concepts. It's supposed to only be one. But beyond that, if you have multiple divisional patents, multiple baby patents, then you can sue on each of them and they have to defeat all of them. So you might fail on 3, but succeed on 1. And even if the opposition manages to overturn one of your patents, they probably won't overturn the rest. Maybe they win on 1 and they overturn you on 1, but your patent is upheld on the rest. See what I mean here, guys? So they're not going to lose their ability to sue not just you, but sue other people. So let's pay attention here. Let's pretend this is Pokemon, right? And divisional patent A is the ball throwing, right? So they're suing Palworld for ball throwing. But there's also the riding mechanic, like riding on Pokemon. That's a separate one. And they don't want to sue Palworld over that. They want to sue a different company. So they use this patent B to sue a different company. Yeah, that's divisional patents. Now, honestly, when I learned more about this, I'm like, that's kind of shitty that the timeline gets to go back like that. Now, I understand why. It's because, well, it's kind of saying, all right, you had a broad patent. Maybe you didn't know what it was at first, but now you've refined it a lot. So let's let you show that you've updated your patent. I kind of get the idea, but it's being used as a litigation tool, as a way to fight people, right? It's really fucked up, but that's the law. And frankly, it sucks, but my job here is to tell you what the law is, whether I like it or not, right? And that's just the law. It's not that I love this. It's not like I enjoy this being a mechanic. right? Kind of seems kind of broken as a legal procedure to go back and say, no, we're going to use that root parent patent and we're going to make it enforceable as of the date of the parent patent, regardless of when it's issued. That's kind of fucked. That's the law, right? So let's continue to hear what he says about this. Once again, I want to hear this is what the Japanese lawyer says about this. The most recent application made by Nintendo and the Pokemon Company is patent number 7545191. According to Kurihara, the companies requested for the review to be accelerated, and the patent was approved on August 22nd. This special sped up examination process, which is interesting, we haven't heard about this from any other outlet, that literally they were rushing in order to sue, was used to approve 3 other patents as well. Based on these circumstances, as the parent patent was registered in December of 2021, these are legally effective against Palworld, which launched in January this year, because the date of the parent patent is December 2021. So they can sue for anything after December 2021. Based on these circumstances, the attorney speculates that Nintendo and the Pokemon Company filed these 4 divisional tactics as a common technique of amending an existing patent for use in litigation against specific allegedly infringing property. It's a litigation tactic. The previously mentioned patent is, in essence, the mechanic of catching Pokemon. It describes in simplified terms the following process: aiming a capture item, a Pokeball, at a character placed on a field, Pokemon, releasing the capture item in the direction determined by the player input, judgment of whether the capturing is successful or not upon contact between the capture item and the Pokemon, changing of the Pokemon status to owned by the player when capturing is successful. In addition, the patent also covers the mechanic of having the capture probability displayed to the player, regardless of whether it uses colors, graphics, or numbers. So it shows right here, here's the ball, right? See, it shows the little ball. Here's the graphic, the ball. Here's the thing. It looks like they used a pterodactyl here, which is kind of funny. They use a pterodactyl, right? So that's what they described it as. This is in the patent filing, this image. So, yeah. Kurihara calls this the killer patent, commenting, "It seems like it would be hard to avoid if you want to make a Pokemon-like game and easy to infringe if you're not careful." The expert does not go into detail about the rest of the 3 remaining divisional patents. However, a rough look at the description suggests the former are related to writing on top of a Pokemon and the latter tie in the specifics of catching Pokemon. So literally writing Pokemon, catching Pokemon. Very, very, very interesting here. So the opinion of them is that they're in trouble regarding specifically the capture mechanic because of that divisional patent. Crazy. And yeah, so that's what I got for that one. That's what I got for that one. So I know a lot of people are not going to like that. I know a lot of people are going to watch this and be like, wow, this is some bullshit. And you know what? That's fine if you feel like it's bullshit, but we can't go out and say, oh yeah, Palworld's going to win no matter what. No. Like Palworld's got a real case. It's got a fight here. And look, I'm rooting for Palworld, but I understand the odds are not good. Like I understand this is like rooting for the underdog. This is rooting for the long shot. This is rooting for the horse that's 20-1 or 40-1, right? They can win. Sometimes the long shot horse, the dark horse wins, right? Sometimes, but they're definitely the underdog in this battle. That's the law. Now, I know a lot of people have said, what if I just wanted to go out there and just file a patent for whatever? Well, all you people on the internet who say, okay, I'm just going to go out here tomorrow and me as a rando on the internet, I'm going to file a bunch of patents. Well, here's the problem. You've got to be the one who created the invention, right? And also it's got to be new and novel, right? So here's some requirements, particularly this is US requirements, but like for patentability, right? It's a little bit of education for you guys here. Once again, educating and entertaining on this channel. To receive a patent, an invention must be new and novel. So you can't just, take somebody's old existing idea and file for it. That's not going to work. Cannot have been previously known publicly. Cannot have been used, sold, or offered for sale in the U.S. at least 1 year prior. It cannot have been the subject of a patent issued elsewhere more than 1 year prior to filing in the U.S., meaning there can't be one abroad as well. So that's a lot, right? So you've got to make sure you're actually coming up with something new and not just like copy pasting.